Hi, and welcome to Criminal Justice in a Nutshell. My name is John Fisher, and today's episode is pretrial supervision. And what we're going to talk about today is the job or what the probation office does prior to actual conviction or actual sentencing. The first thing we're going to look at is pretrial release. Pretrial release is a program that is put together and allows a defendant to be outside of jail while they're awaiting trial. Okay, the defendants can live, work in the community, they can pay their bills, they can be with their family, they can pay their rent. And there's a couple ways to go about doing pretrial release. The first and most popular is ROR, or release on recognizance. Release on recognizance allows you to leave on your own recognizance with the promise that you'll report to the court and you'll come to court when on your day of court. So I'm going to let you out of jail, and when it's time for court, you're going to show up and you're going to face court. This used to be done quite often. It's not done so much anymore, especially in the larger cities. They require bail. Bail is another form of pretrial release, and bail is a way to make somebody put up a surety bond to say, yes, I promise to come back, so I'm going to put up a bond of $1 million. So I take $1 million and I give $1 million to the jail, and they let me out of jail. When I show up to court, they're supposed to give me that $1 million back. Granted, however long it takes to show up to court or until we get the final sentencing, the interest that's collected is kept by the court, by the jail, the city, the county. The next is called pretrial supervision. Pretrial supervision, you find this quite a lot in communities. It's the CHAP program, the custodial house arrest program. You're placed on house arrest. You are only allowed to leave your house when you're going to work or school, and you have to go right back home. You have to get special permission to go to the store. You report daily to the probation department. You do all those things that are necessary for pretrial supervision. These conditions are subject to the court, and each court can make up their own conditions. And this also works into the pretrial diversion program. The pretrial diversion program is an extremely exciting program. This is something that the county attorney or the district attorney can set up and allows for the defendant or the suspect, the offender, to avoid trial altogether. If you qualify for the pretrial diversion program, which we talked about last week, and we turn around and you're offered pretrial diversion, you're put into the pretrial supervision program. You have to write your letters every week. You have to do whatever you're required to do. Only 20% of 100 offenders, so 20 out of 100 offenders, receive pretrial supervision. Most people have to pay a fee, they have to pay bond, or they stay in jail. 20 out of 100 get pretrial supervision. They don't have the money to get out of jail, but they're not really a risk. But they might have a substance abuse problem or another problem that has to be addressed, so they put you on pretrial supervision to take care of that. 90% or about 90% of the pretrial supervision programs will allow you to make one mistake. After the one mistake, they revoke your probation or your pretrial supervision, and you have to go spend the rest of your time sitting in jail. The diversion program I touched on briefly. Here in Howard County, it's $720, and you get put on pretrial diversion. The end results is that there's no criminal record. The arrest and everything is just thrown away. And this is only offered to people who are considered low risk. They made a mistake in judgment, and we want to avoid the stigma or the title of being determined a criminal. So we make sure that we go at pretrial diversion. You write your letters, you report when you're supposed to report, and if you succeed at the end of the 6 months or a year or however long this program was put together, then they let you go and they expunge the arrest. Sentencing is the post-conviction stage. This is also pre-confinement. The defendant is brought before the court, brought before the judge for formal judgment. Okay? And judgment is sentencing. And I really like, and I'm going to get on my soapbox here for a minute, but you hear people say, you can't judge me, you don't have the right to judge me. I look at somebody wrong. I don't like that person. She's not wearing proper clothes, or I don't like homosexuals, or whatever the thing is. I don't like drunks, or I don't like promiscuous people, or whatever the situation or issue. And people turn around and say, you can't judge me, don't judge me. Well, that's not judging. Judging is assigning punishment. If I just say what you're doing is wrong, that's not a judgment. Judgment doesn't come until we impose punishment for the crime. Okay, but anyway, that's my soapbox. So when you're sentenced, then you're judged, you're formally judged. They're given a sentence. But before this can happen, most of the time before this can happen, a pre-sentence investigation is required to be done. This pre-sentence investigation takes into considerations public safety, rehabilitation possibilities, deterrence, retribution. What's in the best interest of the offender, the victim, and society. And that's your assignment that you have to do this week, is you have to do a case study, or your case study this week is to write 2 pre-sentence investigations. And this pre-sentence investigations, you're going to take into account victim statements, you're going to take into account what programs are available, and you're going to tell me and write up this pre-sentence investigation telling me about the threats to public safety, about the possibilities for rehabilitation. What kind of programs can we put that will actually be a deterrent, so that this program will help the offender not to want to commit another crime again. And then the last thing is retribution. How are we going to make sure that the victim receives justice? And this is done. And the judge will review this pre-sentence investigation, and it can influence his sentence. Other times, sometimes you don't have the opportunity for a pre-sentence investigation, and it has to go to a post-sentencing report, and we'll talk about that in a minute. Reflective justice is where each case is reviewed on its own merits and its own issues, its harms, the wrongs done, the context of the crime, and measured against the oppression that's going to come with punishment, what freedoms the person should have, the dignity and equality. With reflective justice, each and every case is taken individually, and the punishment for offending will be applied specifically in accordance with addressing the criminal element or the crime that was committed by the offender. Determinant sentencing is a presumptive sentencing grid, or it is a sentencing guideline. Determinant sentencing, the judge has a chart, and it goes, and they measure the points, or they sit there, and across the top there's going to be offenses, and across the bottom is going to be how many times, and you just match it, and you say, oh, okay, well, this is where this offender is sitting, he gets this punishment, and you don't have a choice. For example, murder in the first degree in the state of Florida is a mandatory life in prison without the possibility of parole. The judge doesn't have a choice in that sentencing. That's the way that it has to be. Okay, so the sentencing commissions make sure that the judge follow the sentencing guidelines and sentence people to the way that they are required to be sentenced. And they also bring issues before the legislature so that the legislature can also dictate what the punishment's going to be. If you read the Article 3 of the Constitution, in there it talks about treason. And treason's the only punishment that is mentioned in the Constitution. But it says that the punishment for treason can be set by Congress, which gives the legislature the opportunity and the ability to impose punishments for certain crimes. And then it becomes the law, and the judge doesn't have the discretion to place somebody on probation or to place somebody on an intermediate sentencing program. They have to follow the law. For example, Texas, if you go to the Code of Criminal Conduct, Chapter 42, Section 12, subsection 3G, you can find that at the Texas statutes page. If you go there, you're going to find that you can't put people on probation for aggravated offenses like rape and kidnapping and sexual assault, child endangerment, and things to that. You're not supposed to be able to place them on probation. But intermediate sanctioning is something that was next in our discussion. And it allows for early release. It allows for a judge to make sentencing, or to give judges more discretion in their sentencing so that they can be a little imaginative on how they're going to address retribution and rehabilitation and deterrence, and make sure that each individual gets a specific sentence. Okay, so the PSI, let's talk about the PSI a little bit more in the next couple minutes. It's intended to provide a timely, relevant, and accurate information as regards to the criminal justice system and the crimes that are associated. Okay, the probation officers are not seeking to change the judge's mind, they're just seeking to influence the judge's mind. They suggest institutional programming like deferred adjudication programs like SafeP and CRTC and other programs that are available to the probation department. The PSI allows paroling authorities to compare defendants' versions of what happened with the police investigations and how that happens. And it serves for a basis for writing treatment plans and helping probation officers properly deal with the rehabilitation side of an offender. The post-sentence report is written if you don't have an opportunity for a pre-sentence investigation, or you use the jury for sentencing and the jury doesn't take into account the pre-sentence investigation. They punish on the way that they deem is most important. It's written after the defendant has pled guilty and after he's been sentenced. And this is part of what's called the Pen Pack, the penitentiary program. Okay, so on page 83 of your textbook is the case study. You're going to see two cases. One is from Defendant Green and the other is Defendant Tough. You're going to read about their information, you're going to read about their crimes, and your job is to write a PSI, a pre-sentence investigation for both of these individuals, and then turn them in a .doc format down below. Go ahead and upload that. The discussion for this week is probation conditions. And should probation conditions be left up to the discretion of each individual judge, or should the legislature set those conditions? What I need from you to do, or what I need you to do, is to establish your argument and then make sure that you defend and back up that argument with the literature, not only in the textbook, but outside of the textbook, using academic journals and academic literatures to support your specific stance in this. Make sure you respond to at least one of your classmates by the end of the week and reply to anybody that responds to you no later than Sunday. Okay, this is John Fisher with Criminal Justice in a Nutshell. Have a good day.